Okay, good afternoon, everyone. Today is Thursday, April 2nd. The Senate is still in session, so we will not be starting with our bill hearings. We will be on hold, just to let everyone know who's waiting in the audience and all our members. We're going to start with our vote session first, and I'm going to wait for a few more members to get here, hence the reason why I'm kind of talking slowly. But I wanted to start with, I'm going to start with, okay, everybody's here. I'm going to start with Senate Bill 822 as a discussion, just to make sure, okay, let's do that. To make sure that, that we're okay and in a good place. We passed out the House version, but there have been amendments that have been offered, and either Council Clare or either Delegate Embry, if Senate Bill, I'm starting with the end in mind, Senate Bill 822. Thank you, thank you. So we're talking about, okay, hold on, you guys, you all know I cannot have multiple conversations. This is one thing I'm not good at, I'm sorry. There's a lot of things I'm not good at, but that's definitely one of them. So what I said is I wanted to have a conversation first on Senate Bill 822 as amended. So we want to talk about the amendments first. We voted out the House version, House Bill 467, but the Senate has amended it, and what is before us today is Senate Bill 822. Is there a motion on the amendment? Okay, so let's talk about the amendment first, and then we'll go from. No, there's amendments. I thought there were amendments.
We don't have amendments in front of us.
The bill incorporates the bill.
Okay, well, we'll talk about the concept of the amendment in just a moment. Just a moment. All right, we're back. So what we're going to do is, all right, here we go. I know I had your attention for a second, then I lost it. So let's get it back. All right. So on Senate Bill 822, I'd like for Council to explain the differences or what's going on between House Bill 467 and Senate Bill 822, please.
So Senate Bill 822 is the cross-file of Delegate Embry's House Bill 467. We passed House Bill 467 earlier this session, and Senate Bill 822 is exactly the same as the way we passed House Bill 467, except it adds something additional, and that is a provision that says for an administrative proceeding involving a person who was erroneously convicted, the bill prohibits a county from being a party to the proceeding and a state's attorney from designating a county as a party to the proceeding. And that provision would apply retroactively. and must be applied and interpreted to affect any proceeding before an administrative law judge brought before October 1st, 2026.
And if you have any questions, feel free to ask. I think I hear a question from Delegate Woods or either Delegate Williams. I wasn't sure.
Okay, I guess it's me, Madam Chair. I guess I'm just trying to wrap my head around this because I get why the county would be exempt, I guess, from being involved. And I understand why we would probably want the state's attorney in the county in which the conviction occurred to not be involved. But are we saying that also the state's attorney in the county in which the conviction was involved in is not allowed to refer that to a different state's attorney in a different county? Oh, no, I'm not hearing this right. Okay.
Delegate Embry?
So my understanding, and thank you, Claire, for notifying me about this. So do you remember Delegate Griffith's bill? This is the issue of the split in costs for wrongful convictions. I believe that what this is addressing is, if you recall, some locals are moving to intervene. The counties themselves are moving to intervene. So the state's attorney currently is a party, so it doesn't change that. What it would say is it would clarify that the county may not be a party. I think it may be addressing that issue. So I just wanted to be transparent because that is different than what the rest of the bill does, but it might preclude the county from, I mean, they may not be allowed, the administrative judge may say, no, you can't be a party, but this would make it easier for them to say that. Thank you.
So if you can just answer this question, does that mean that the county would then be exempt from liability? No?
No, it wouldn't affect any of that. It just means they wouldn't be able to be involved in deciding how much.
In deciding how much, not that they would be exempt from having to pay if they were the wrong.
Right, does not change that.
Okay, thank you.
Remember this, the amount that the county has to pay is predetermined as it stands today, right? The counties pay a portion. 50%. 50%, okay.
What was that last part? You said 50% per?
We passed a law that they have to pay half, and that was the bill that we heard trying to change that. And so the reason I bring it up, it's not that I have any problem with it, it's just that I wanted to be transparent and know that this was a different issue than the bill.
Delegate McComas and then Delegate Congo.
I think if somebody could enlighten me, it was my understanding that the county was not at the table when that decision was made. It was made by the governor, or by the governor and the legislature, that they were to pay 50%. Is that fair to say?
I don't know the history. Does anyone have that answer? I don't know the history there.
Well, I know that the counties were not notified about the 10%, 90% on the retirement for county and for the state employees or whatever. It was for one of the retirement.
Okay, so I just want to make sure, Delegate McComas, I don't know the answer to your question with respect to whether or not the counties were able to weigh in, but I think Delegate Congolo has something to add. The other part is this is something that we still have DPW involved in, if I understand, Department of Public Works with the Department of Public Works?
Right.
Board of Public Works.
Yeah, the Board of Public Works, though, is from the state, and saying that the county can't be involved, I think, is serious, because they're going to be paying half the freight of whatever it is.
That's why we're having this discussion.
Okay, well, I don't think, I think it's going to go to court if it gets passed with saying the county has no say and they have to pay.
It doesn't say they don't have any say. It says that they're not going to be a party, but just to make it clear for the record, it just says that they're not going to be a party. Okay, so there's that. Delegate Congolo?
Have we heard from the county at all? Have we gotten any feedback? Okay.
Yes, the county did weigh in, I believe, during the hearing. Yeah.
Griffith's bill, not this bill, but
Okay. Can you refresh my memory? What was it that they had,
If I may, Madam Chair. So the issue is the counties, I think, objected when the bill was passed, that the 50-50 split and the process for giving, remuneration for people who are wrongfully convicted, and they would like it changed so that the state bears 100% of the burden. That was the bill that Delegate Griffith had. And so, again, under existing law, they're not a party. That's just, they're not listed as a party under existing law, but this amendment would say explicitly they're not a party. The state's attorney remains a party, and they are locally elected, but the county, as amended, would not be allowed to be a party. As the chair said, that doesn't mean they wouldn't have a say, but they wouldn't be a party.
okay, and they're aware of this change?
That I don't know. This came over from the Senate, and I didn't realize that they'd added this, so I don't know that.
Well, in the sense that there was a hearing, and it was on the vote list, they have constructive knowledge. I can give you
That's
that, yeah. We can also look to see, I don't know if we had, I'm looking at the witness list now, and I don't see the counties here, which is interesting. Delegate Arica.
Thank you, Madam Chair. So just to make sure I'm following this, when the counties are not a party, it means that they are also not going to be financially responsible, or no? It just means they can't be a party to the case in any way? Okay, so we would probably need to hear from them, because how does that make, so they could still be on the hook, but they couldn't be present? That...
adds they may not. So the parties are listed and they're not one of them. This says they are not a party, so it goes a step further.
So just to make it clear, because I'm not sure if I heard Delegate Embry, but what she's saying is that currently the county is not a party, okay? What the Senate did was make it explicit that the county is not a party.
Okay, so it doesn't really change the operation, but of current policy. What happened to the other bill you mentioned? Did that bill move? The Griffith bill that was gonna, it didn't move? Okay. Okay, yeah, his bill did the opposite. Yeah,
Well, sort of. I mean, right.
essentially.
Trying to place the financial, the amount totally on the state to pay.
Only on the state.
This isn't the opposite. This goes to the question of the county's role in deciding the amount,
Okay.
arguably. And again, it doesn't mean, as the chair said, they can't be heard. It just means they're explicitly not a party, which again, they aren't. Their parties are listed and they're not listed under current law, but this would say.
What would be the avenue for the county to be involved in the litigation if they're not a party? How would they come in? How would the judge give them an opportunity to speak? Why would a judge give an opportunity for someone that's not a party to speak? I don't know, I'm not sure. I mean, there could be an avenue, I'm not a lawyer, I just play one on TV.
Just to make clear, is the state's attorneys, the county, the local?
The state's attorney and the attorney general are parties.
And it looks like the State's Attorneys Association is unfavorable.
But not on this issue, I don't believe.
Okay, something else.
Right.
Okay. So, all right, well, maybe if somebody knows how the county could still get into the process without being a party, that would be a good question just to answer.
So the question is whether or not the bill only deals with the compensation? Oh, the section dealing with the county? Well, it's in two places. I'm going to ask counsel, the section on the county not being present, or sorry, not being a party, is where? Because I can't.
At the end of the bill, of Senate Bill 822.
Yeah, that's not going to work for me.
Page 9.
Okay. Okay. So Delegate Williams, you were saying that the section on, does not deal with only deals with the county not being a party with respect to the compensation or the award?
Yeah.
Is that a correct question? Is that a correct statement, counsel?
I can't speak about the details of one of these proceedings because I'm not familiar really with these proceedings for erroneous conviction.
Okay. So what I see, so I see what Delegate Williams is stating, where it says a county may not be a party to a proceeding under this subsection. And so the question is, what subsection is being referred to?
Oh, it would be subsection B then, the whole 10501B, which is set forth in the bill, starting at page 8.
Okay. Does that answer? Okay. Do we have any other questions? Delegate Simpson?
It seems to me that it's like, in that section, it's also saying that the state's attorney then can't list them. So I'm wondering if it's just trying to say that they can't, the state's attorney can't then say, well, we'll make it the county and the county attorneys have to take care of it, as opposed to them, the people that are listed. I wonder if that's the clarification. Because it's got two clarifications there. The state's attorney may not designate a county, and I remember some bill, one of the testimonies we have, that folks were confused as to why they were a party to the case. But I don't remember if it was this or not.
This was the Senate's amendment, meaning, yeah, I'm gonna look and see, and if anybody else gets the answer before me. This is Senator Smith's, Chair Smith's bill, and I am not sure who offered the amendment.
It said by the it says by the committee. It's a
I know,
committee
but I mean,
amendment.
yeah, it's a committee amendment. I think what he was asking was specifically who was the person who might have, been the one who asked drafting. Delegate Cardin?
Is it possible that the way they understand this is that if you're not a party to it, that you then can't be, have any liability attributed to you? There's no, because to me, it seems like the reason they would want to do this is to try and limit liability. Like that, why else would you say that you can't, if you're already not a party, why else would you, specifically say you're not a party? And how do you then have liability, as Delegate Erickson was saying, if you're not party to it? I don't understand how that's possible.
Okay, so, and then I'm going to hear from Delegate McComas, and I didn't mean to cut you off, but here's what I think we should do, because we have more questions and answers right at this particular moment. I'd like us to all take some time to review the bill. We're going to have another vote session tomorrow. Review the bill, and then we can also, that'll give me time to look at the Senate hearing and the Senate vote session to see if I can ascertain the answers to some of these questions that you all have, because this might have been discussed. Okay? Delegate McComas?
Madam Chair, I would also suggest we maybe get an Attorney General opinion too, as to the fact that since they're not a party, does that mean they're not liable? Because as I recall, the counties were supposed to share in the erroneous payoff and from last year. Now, I mean, I could be wrong, but I think that's a concern.
No, I think you make a good point, and that's something that I want us, I mean, I'm not saying I'm the only one that can look on YouTube at the Senate vote session. I want us all, anybody who's of mind, to look at the Senate vote session, listen to their discussion, and then let's come back tomorrow and let's see.
But I think we can get an AG opinion, I bet, real quick.
If we need one, given that.
I think we should do it to just make sure we're good.
All right, thank you. And the other thing is, I want to also clarify that anyone in this committee can ask for an AG opinion. So Delegate McComas, if you would like to, you can ask for an AG opinion, okay?
Only thing is that whatever I ask for, they're going to answer. And basically, I think you and staff are probably in a better position to correctly answer the question. But, and I really
take-
am concerned about the issue of liability and not,
Okay,
Yeah.
I'll take that under advisement. Delegate Congolo.
Would it be too much to ask if one of the team members, maybe Hunter, send us the clip of the hearing and the discussion on the Senate side of?
That's an easy fix. That's not a problem. Did anybody else have any other questions, thoughts? Okay.
Sorry.
Delegate Embry?
Again, I apologize for the late notice, but I have been texting and trying to get more information as this has been going on. And so MACO is aware of this amendment. They are not thrilled with it because, for the reasons indicated, it is probably going to make it harder to intervene, not totally foreclosing it, but probably would make it harder, although intervention is not a right under current law, but that is their view. But anyway, you should all talk to them, but I just wanted to share that. But it would not impact their being on the hook for the 50%. And I misspoke, it was not a statute, it was the BRFA that the 50-50 split originated in.
Okay, so everybody has their homework for tonight, amongst other things. So take a look, take under consideration what Delegate Embry just said, unless anyone is ready to vote on the bill now. And I'm not seeing that you are, so let's move on. Okay.
You know, what's funny is that you can't look under all the, you know how you look under all the testimonies, because it's under, all the testimonies for 791 is the wrong bill.
I don't understand.
Because I tried to look to see if maybe somebody said something about counties in there, but it's the wrong bill.
Interesting. Okay, I can see testimony, but under Senate Bill 822, I can see testimony on mine, so maybe we should compare.
No, I mean, yeah, the all, when you look, it has the one that says of all bill.
Oh, okay, yeah. Okay, gotcha, the merge one. Okay, do the individuals, and that way you can look at it. All right, moving along, I'd like to move to Senate Bill 323. This is Senator Smith's bill that we heard, I guess, 2 days ago.
Second.
Thank you. There's a motion for a favorable and a second. We heard, like I said, we heard this yesterday. Are there any questions, thoughts, concerns? Delegate Arakan.
Thank you, Madam Chair. This is the auto charging bill, correct?
That is correct, along with removing kids from adult detention.
Okay, yeah, I think, obviously, I believe we already moved a bill earlier, didn't we, about kids in detention? Really?
No, we did not.
Oh, we had some
heard
other
it
sight and
in the
sound.
House. We heard, no, this is, you've got your,
Okay.
all the wheels are turning correctly. You got it. We did not move, we heard the House bill, which
Okay.
was two separate bills, as well as over in the Senate. One bill dealt with auto charging, the other bill dealt with getting kids out of adult detention and providing, because of the federal law that says that they're supposed to be separated from adults by sight and sound. What we have done is combine, what the Senate did was combine those two bills into one, and that is what we have before us today as Senate Bill 323.
Okay, and how, that's not Delegate Moreno's bill that we passed already?
The bill that we passed for Delegate Moreno was restrictive housing.
Oh, that's right.
Yes.
Okay, all right, that helps me a lot. So just on the topic of the auto charging, I mean, look, there's still some really concerning, serious crimes that we are going to be essentially, it's almost like shifting the burden from OPD to make a case for why we should be moving the case down. And then we're going to shift it so that now the state's attorney's office has to make the justification for why it should move up. But here's my comment, and I've heard a lot from both sides about this. Sometimes children act in such an egregious manner that it's okay to make it a little scary. Like, yeah, stop armed carjacking people, or you could face adult court. And I think that it's possible that for a child who has, and oftentimes repeated, I mean, I just got a text yesterday that two 11-year-olds tried to steal a car in my area. You know, what are we doing here? And so I think that there can be an argument made that when children are allegedly committing very adult and very dangerous crimes, that it's okay for people to have potentially serious consequences and to feel the weight of that. I think it's very reasonable. And again, OPD does, of their own, admission many times before in this committee, said, we always try to move these cases down, always. So at the end of the day, the hearing's going to happen either way. The fight is going to be had either way. And I don't think at a time when we do have a problem with juvenile crimes specifically, in many communities, especially East Baltimore County and Hartford, I don't think it sends the right message to the public that we are going to be not taking this as seriously as I think we probably should be, because some of the crimes in here are still extremely serious crimes. So I will still be red on this bill, despite the edits made by the Senate, which I think obviously certainly carved out some murder and rape, but there are other serious crimes in there that I think deserve a very strong reaction so that hopefully the children will see what their future could look like if they continue this behavior.
Thank you. Delegate Woods?
Yes, thank you, Madam Chair. I do want to respond to my colleague's comment. I certainly do not believe under any circumstances that 11-year-old children should be even considered to be charged as adults. I do understand when we talk about the seriousness of a crime, but I think the level of maturity, a child is a child is a child. And I believe that the level of maturity, the context from which these behaviors come from should all be considered, and certainly would not agree that we should charge children that young under any circumstances as an adult. I think children should start where they are, as children or as juveniles. And as the legislation currently says, the decision can be made by a judge depending upon the gravity of the crime that was committed as to whether a child is eligible. But I still would adamantly agree that we should never be charging an 11-year-old child as an adult. Thank you, Madam Chair.
Thank you. Delegate Arakan?
Thank you, Madam Chair. That was not even close to what I was suggesting. I was merely mentioning that we have some juvenile crime issues. This bill doesn't even touch on 11-year-olds at all. So just for the record, that was not what I was meaning. We should include 11-year-olds for car theft. That's not even part of the bill, so.
Great, gotcha. Oh, just want to, it's good to correct the record because this is a public record here. Sure. Delegate Woods, did you want to respond to the response?
I only responded to what I thought I heard you say, that there were some young people in your neighborhood, 11 years old, that were trying to steal a vehicle, and that you used that as a preface to why you were going to be voting no on the bill. If I heard you incorrectly, my apologies.
Delegate Moon?
Thank you, Madam Chair. Just for the record, I also want to clarify some of the recent dialogue here. Just because a juvenile is charged as a juvenile and not as an adult does not mean they are not facing very serious consequences. And in fact, this body just a year or two ago had a very vigorous debate about whether if you were caught with a handgun as a juvenile, you would still be incarcerated or not. And much to the disappointment of some of the members of this body, the decision that was made at the time and went forward was that you could, in fact, be incarcerated as a child in Maryland for handgun possession, and nothing about what we are doing today is going to change that. However, what does change is the rules that you are going to face as a defendant. And in the case of some of those offenses, you're talking about subjecting children as young as 10 or 11 to mandatory minimum sentences. And I think those are the rules facing you in the adult system, which, as for all the other reasons you heard, are highly inappropriate for a young, unformed mind that may nevertheless still be made to face very serious consequences, even incarceration, but at least under the auspices of the juvenile system with the appropriate supports that we are attempting to come up with that some of the members of this body have been trying to make sure we put together, still a work in progress. But again, a vote on this does not mean a vote for no consequences for these children. Thank you.
I saw Delegate Valentine next, and then Delegate Phillips.
Madam Chair, and I'm going to shift gears because this is two different bills, so I want to go into the juvenile facility part of it. I just want to confirm, because I've had conversations with you prior about this. I just want to make sure, and I'm looking at the reprint, and I just want to make sure I'm reading this right. On the reprint, it's like the next to last page where it says a child may be temporarily held for processing in an adult jail or correctional or detention facility that does not have a secure juvenile detention area if. My concern is for the agencies that have, I believe, what's considered a secure juvenile facility, but it's under the same roof, and they have to be held for a couple of days because they haven't been picked up with these facilities because they're separated by sight and sound, but they're under the same roof, still be able to hold these juveniles for a couple of days, well, until they're transferred to somewhere else, if that's all that they have, based on what I'm reading here. So it would be a complex, it's separate but under the same roof. Does that handle that? Am I reading that properly? That's where I was reading from, was C, because it's considered a separate secure juvenile area.
Not have a secure juvenile detention area.
I think they would be covered. I just wanted to clarify that.
I would agree with Delegate Cardin. In the sense that if there is a secure juvenile detention area, given what you just said, then that would be fine with respect to following federal compliance.
That's what I'm trying to cover. Thank you.
Delegate Phillips.
Thank you, Madam Chair. This is a discussion that has been taking place over a very long extended period of time. The idea that Maryland would continue to treat and charge youth as adults. It's my understanding something like 14 to 15 years. We've been going back and forth. Maryland, per capita, charges more of its young people as adults than any other state in the nation except for Alabama. And of those that it charges as adults, 9 of 10 are people of color, 8 of 10 are African Americans. In this charging of individuals as adults, the system, in my mind, and I'll be voting green on this, has done a disservice to our taxpayers. For many of those individuals who are charged as adults and start in the adult system, we're talking months, sometimes years, and about 80% of them end up back in the juvenile system. While they're in the adult system, they get no services. So if we think about that, we take 80% of the youth, we break them, we send them back to a system that they should have been in the entire time, and they probably still don't get the services that they deserve. This bill begins, in my mind, to correct that, and it's only a beginning, because in my mind, we should be starting all youth in the juvenile system and working to improve their lives and to do a better job by the victims so that they don't recidivate. After much discussion with the Department of Juvenile Services and their ability to address what is approximately 500 youth a year that would come out of the adult system and move into the juvenile system, my sense is that they want to see if they can handle these youths and actually provide the supervision, ensure that they do not recidivate, but at the same time, provide the services that these young people deserve. And also to reduce the cost that we experience when we put these young people in adult prisons that are not built to accommodate them. So I would just say, while I am not enamored that this is the best piece of legislation we could get out, I think this is the right piece of legislation for where we sit today after 14 years and after being compared repeatedly to the state of Alabama. I don't think that's a badge of honor. And after learning that our system, we're so bad that our data is not even included in the national calculation for the way we house youth. So I just want to take a moment and thank our chair of Judiciary, who's been working on this for a very, very long time. And I will go on record as saying the chair of JPR as well. And as a result, I am going to be very supportive of passing Senate Bill 323. Thank you, Madam Chair.
Thank you. Any other comments? All right, seeing none, please call the roll.
Senate Bill 323, Senator Smith, Juvenile Court, Jurisdiction, Detention, and Confinement, Youth Charging Reform Act. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes no. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. Delegate Phillips. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes no. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher is absent. Delegate McComas. No. Delegate McComas votes no. Delegate Moreno. Yes. Delegate Moreno votes aye. Delegate Aricon. No. Delegate Aricon votes no. Delegate Taylor.
Yes, can I explain my vote? I vote yes reluctantly because I think that after 14 years or 15 years, we could have figured out at this point how to make this an all-inclusive bill. And DJS and whomever else needed to have figured out how to house our youth in proper accommodations. I think at this point we should have been beyond where we are now. And the reason why I'm voting yes is because I'm thinking about all the kids that we will help. And, you know, my heart still goes out to all the ones that will still be caught up in this system where we're still charging our kids as adults. So I'm a yes. Thank you.
Delegate Taylor votes aye. Delegate Simpson.
Yes. Thank you, Madam Chair, and thank you to all the delegates and the senators who have put forth this bill and continued to put forth this bill time and time again. Our children should have never been charged as adults and should never have been housed with adults. And I know it doesn't go as far as we would like it to go, but I am appreciative of the step forward. And I know that the people in Frederick, I know that the advocates in Frederick, I know that the families, the parents, the children will continue to push us to make this to the point of where it needs to be. And I am thankful that this body is going to be able to move forward, at least for the 500 kids that we can save for now. And I know eventually Maryland will do the right thing, and Maryland will get the kids where they're supposed to get and get the treatment that they need. And so I know that the advocates that have been contacting me all day, we will celebrate the progress we have made, and we will not give up on any child. Thank you.
Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes no. Delegate Moon.
I just want to say, colleagues, I completely appreciate the perspective you're coming from. I also do see this bill as substantial progress. I've seen many of my colleagues carrying the water on this issue for many years and it not get as close as it has right here. And, you know, as we noted in the discussions on the prior debate about incarceration of children in Maryland that I alluded to, I think there were many who left disappointed that conversation ended where it did. But at the time, we did promise that this was an ongoing process to keep looking at different aspects of what was going on with children in Maryland and to continue seeking improvement. And here we are, just a year or two later, again, continuing to improve the conditions of confinement for those children who do find themselves in that circumstance, and to, again, keep looking at the process to see whether it's as good and as fair as it can be. So this is evidence that we're making good on that promise a couple years ago to keep looking at this and improving on this process. And I will say again today, for those who don't like it from either perspective, we are obviously going to continue to monitor public safety outcomes, because that is what this is about, in addition to whether we are doing right by the children. So thank you. This is a yes vote.
Delegate Moon votes aye. Delegate Conaway.
Yes.
Thank you. I recently heard in our discussion some information about 11-year-old children breaking into a car, breaking into cars, trying to steal cars. I'm of the opinion that the children need additional education and not tough love. I think that the children need education because they don't even know that they don't have the skills and knowledge set to steal a car. They break in the car, pop the lock, try to figure out how to steal a car, and don't know they're in the computer age and it has a chip in it. So we have to, in my opinion, I think we have to push education a little bit more and talk to the children or the youth and explain it to them. Listen, don't break in the car, don't steal the car. What's that gonna do to you? Oh, I'm too young to get incarcerated, I'm too young. Yes, but 13, 14, 15 is just around the corner, and you're developing this pattern, and we want to help you. So I am against the tough love, and I'm for the education, and I'm for this bill, and I thank you.
Delegate Conaway votes aye. Delegate Woods. Delegate Woods votes aye. Delegate Williams. Delegate Williams votes aye.
The chair votes aye, and I'd like to explain my vote.
Madam Chair votes aye.
My vote is obvious, but I will say on the record a conversation that I've had with Delegate Conaway, and I agree with him 150%, and that is that we teach our children a lot, but we do not teach them the legal system. And one thing that we did with the Child Interrogation Protection Act was we played a video, and that video was of a child who literally did not understand what they were agreeing to when they were being read their Miranda rights. They didn't understand that. They oftentimes may think that consequences are temporary. If something happens to me, it's temporary. They don't necessarily see it as the life-altering decision that they are making. So I promised Delegate Conaway and I will keep that promise that over the interim, we will work together and we will create a bill that, and I know public schools do not like us delving into their curriculum. I know that, but we will be delving into their curriculum, and we will put in some requirements of the legal system so that children understand this is a permanent consequence that they are making. They are altering their entire life cycle by making some of the decisions that they're making. And so that is on the record, and that is a promise that, that I make to you, and I guarantee that promise. So thank you. I'm an aye.
Madam Chair, the final tally for Senate Bill 323 is 14,5001. The motion carries.
And I thank you all for that discussion. I thank you for your votes either way. I understand, and I appreciate, and I respect you all. Delegate Stinnett.
Yes, thank you, Madam Chair. And my apologies for wanting to say something after we had gone through the voting, but this just kind of reminds me of just to share an experience. Some years ago, I used to be chair for a charter school, and this was a location at one of the, actually it was in the 40th District, the Mel Building, and they had 3 schools in one. And I was chair for middle school, high school, but there was another school that was in that I was really against on having that school in that building. And just kind of referenced as far as what this bill is about, that these were older kids, and pretty much you had the choice, either you go to jail or you go to school. And I had an issue with this school being inside because I saw them prey on some of the younger kids. And I think a lot of people just didn't realize how affected that was happening to the younger kids. And this is, to me, is very similar to as far as having kids in an adult site and really not realizing as far as how damaging throughout the years that this can be, which I knew on that level it was very damaging as well, that fortunately within a year or so we were able to remove that school and they lost their certification and so forth because it's just obviously the program wasn't working, but also just the damage that a lot of these older students had on these younger students. Thank you, Madam Chair.
Thank you. I appreciate your remarks. Thank you so much. Members, again, I thank you. We're going to move on. We're going to continue on with our vote session, and then we're going to move to our bill hearings when the Senate is available. Next bill that we're calling up is actually, you'll do it from back here? That's fine. Okay, but I just wanted to make sure you were in place, so you're good. Okay, all right, just wanted to make sure we have everyone in place. So Senate Bill 252.
Second.
Thank you. There does not appear to be any amendments. Right, so we have no amendments. I will say that the Senate bill, we passed this bill out in the House under House Bill 284, and the Senate made one little change. Holly, if you want to go over that change, you can. Oh, what is this, 7, from the 7 voting? Everything's the same, straight favorable?
Yes.
Okay, all right. Straight favorable on Senate Bill 252. I heard a motion and I heard a second. Are there any questions or thoughts, concerns, or criticisms? All right, seeing none, I will call the roll. Just one moment. Delegate Williams.
Oh, shoot. I was just going to add, Madam Chair, it looks like the Senate JPR voted it out favorable 10-1. So I just wanted to note that for the record. On 252.
On 252. Thank you, Delegate Williams. Okay, I'm going to call the roll here for Senate Bill 252. The Vice Chair.
Yes.
Vice Chair is yes. Delegate Valentine.
No.
Delegate Valentine, no. Delegate Embry.
Yes.
Delegate Embry, yes. Delegate Cardin.
Yes.
Delegate Cardin, yes. Delegate Phillips.
Yes.
Delegate Phillips, yes. Delegate Congolo.
No.
Yes.
I'm sorry, I'm looking at the Senate on the floor, third reading. It looks like there were 8 noes and 35 yays. So I just wanted to make that comment. Thank
Okay.
you.
Delegate Congolo is a no. Delegate Stinnett.
Yes.
Delegate Stinnett, yes. Delegate Simmons? Yes. Delegate Simmons, yes. Delegate Boucher, absent. Delegate McComas? No. Delegate McComas is a no. Excuse me, I just made you a yes. change that really quickly. Okay, Delegate Moreno. Delegate Moreno, yes. Delegate Archon. Delegate Archon, no. Delegate Taylor. Delegate Taylor, aye. Delegate Simpson. Delegate Simpson, yes. Delegate Mangione? Delegate Mangione, no. Delegate Moon? Yes. Delegate Moon, yes. Delegate Conaway? Yes. Delegate Conaway, yes. Delegate Woods? Yes. Delegate Woods, yes. Delegate Williams?
Yes.
Delegate Williams, yes. I get 13-5 with 1 absent. Okay. The motion passed. Our next bill we have is Senate Bill 160. Is there a motion? Is there a second? Thank you. I heard a motion and a second on favorable for Senate Bill 160. Is there any question, concern? This one has a change. Finally, we get to a change. All right. Holly, would you mind explaining the change?
Yeah, there's a minor change that was made in the Senate on the House floor. Senate Bill 160 alters the existing civil penalty that applies to the failure to meet the required security features by establishing that for a first violation, a $250 fine, and then the existing maximum civil penalty of $1,000 will apply for second or subsequent violations. So it's just altering the civil penalty. Everything else in the bill is the same as the House passed it.
I thought I heard a motion to move the amendment.
Well, no, it's already in the Senate bill. We're moving it. Yes,
Oh,
we're
okay.
moving it favorable as the Senate passed it out with that amendment.
Oh, okay, gotcha. Yeah, I heard a motion on the bill. Senate, I'm sorry, I was about to make you senator. And we would never want to do that because we don't want to lose you, Delegate Valentine. Delegate Valentine, please.
Thank you, Madam Chair. And if I could just clarify with council, the first violation is not exceeding 250. It doesn't mean it is 250, correct?
Maximum of $250.
Not to exceed 250.
Exactly.
Okay, thank you.
And then the second is the penalty that was there before, the $1,000 maximum.
Correct. Thank you.
Members, do we have any other questions? All right. Seeing none, I will call the roll. So no questions, right? All right. The Vice Chair.
Yes.
Vice Chair votes aye. Delegate Valentine.
Yes.
Delegate Valentine votes aye. Delegate Embry. Aye. Delegate Embry votes aye. Delegate Cardin.
Yes.
Delegate Cardin votes aye. Delegate Phillips.
Yes.
Delegate Phillips votes aye. Delegate Congolo.
No.
Delegate Congolo votes no. Delegate Stinnett.
Yes.
Delegate Stinnett votes aye. Delegate Simmons.
Yes.
Delegate Simmons votes aye. Delegate Boucher absent. Delegate McComas. No. Delegate McComas votes no. Delegate Moreno. Yes. Delegate Moreno votes aye. Delegate Archon. No. Delegate Archon votes no. Excuse me. Delegate Taylor. Yes. Delegate Taylor votes yes. Delegate Simpson. Yes. Delegate Simpson votes yes. Delegate Mangione. No. Delegate Mangione votes no. Delegate Moon. Delegate Moon votes yes. Delegate Conaway? Yes. Delegate Conaway votes yes. Delegate Woods?
Yes.
Delegate Woods votes yes. Delegate Williams?
Yes.
Delegate Williams votes yes. (14-4-1) Okay. 14-4-1, the motion passed. So that concludes our vote session for today, April 2nd. Hang tight. We're going to wait for the Senate to come around. I think I should get that on a T-shirt.
We're going to watch the vote session together.
Yes, we could do that. So, oh, that's right, we could do that. Hold on, 1 second. Hold on. We are adjourned with respect to this vote session. We will reconvene once the Senate is available. We're assuming that'll be around 2:30, so we'll reconvene at 2:45. Thank you. We are adjourned.